slides. Over to you, Philippa.
Great, thanks, Dina. Can everyone see that okay? Got my slides up? Great. So welcome everyone. It's really great to have this opportunity to speak to you. I'll start off just by introducing myself. Zina's already said something about me, so I will keep this brief so I don't bore you all. The headline is that I'm a UK and European patent attorney. As Zina said, I'm a partner at Dehns. I have an engineering degree and all of my work is in technical fields that I'm qualified to work in. So I have a number of years of experience, as you probably can tell from my face. And I work with a large variety of clients. So I have some individual clients, private individuals who've come up with an idea and then begun to build their own company, right through to large multinationals. Over the years, I've worked in a large number of different engineering sectors. My main field of expertise is mechanical engineering, and some of my main clients at the moment work in green energy, aeronautics, and oil and gas. So I've given a précis there at the bottom of the slide of some of the types of work I handle, but it really is what we're going to talk about going through here. So I'm not going to go into detail now. You can see what my experience is there, and obviously my web bio and my LinkedIn profile give more detail. So I'll move on to the more interesting things to talk about. Just quickly to introduce Dehns, I've said I'm a partner in Dehns. We are a legal firm of patent and trademark attorneys. We're one of the largest in Europe. Again, there are quite a few facts on this slide. I won't go into all of them in detail. It is worth just mentioning we're top tier ranked, as you can see there, by a number of different directories. And we have experience in all the relevant areas that I'm going to talk about today to do with IP, both protecting your IP, but also protecting yourself from other issues around IP that might impact on your business. And it's worth mentioning our values, which are very important to us. And our values are being approachable, smart, and enterprising. And that's something that we do take seriously, both externally working with clients and also internally as an organization. And that enables us to deliver a really excellent service. So moving on to the main structure of this talk and what you're here to hear about. So how do you build an IP strategy? What is an IP strategy? So IP is made up of a number of different factors. When you're thinking about an IP strategy, the main areas to consider are here on this slide. Apologies. Apologies, give me a moment. Right, so starting again, so looking at this slide, the main areas to consider are freedom to operate. Now that is whether there is any IP out there belonging to other businesses or private individuals that could stop you from doing something that your business wants to do. Then the main forms of IP, we've got patents, which are a registered right, which are to do with technical areas, and we'll talk about that in more detail later. Then we've got trade secrets, which often overlap with the subject matter of patents. They're not a registered right. Again, we'll talk about it further later on. We've got designs, which are more to do with the aesthetics of a product. Again, I will discuss it more in the slides to come, but there are either registered designs or unregistered designs. Then there's copyright, which I won't talk about here, I'll just describe later on. It's a very wide area. It's not a registered right. It is often relevant to what you're doing in some way, but we'll come on to it. And lastly on this slide, but not lastly in terms of importance, there's trademarks, which is what most people tend to be familiar with, even if they don't have much experience of IP. You'll probably all have seen TM or R at the end of a brand name on packaging, for example, but it is key to a lot of businesses. So moving on to talk about this in a little bit more detail. So what can IP protect? So it's important to say that IP can't just protect an IP idea. People quite often say, oh, I've got this great idea for something. Well, that isn't normally enough. So the different forms of IP, as I mentioned before, some relate to technical inventions. So there we're looking mainly at patents and trade secrets. So the important thing there is that we're looking at an inventive concept. So thinking about a typical product, a patent wouldn't normally be for that product. It would be for something that was new and advantageous that was embodied in that product. Again, we'll talk about this more as we go through. IP can also protect various aesthetic creations. So that can be the whole of a product, but it doesn't need to be. It can be some specific part of a product, or indeed something else, so some advertising material, for example. But it doesn't relate to technical functions. So for example, thinking of design protection, that is all about how something looks, not about how it works. And then we've got brand identity, which is largely the trademark protection. And for most businesses, that's going to be really key to think about that really early on. So starting a new business, what are you calling your business? How are you branding the business? But then also any new products, any new services, really looking at that branding early on and making sure that you have the right protection in place and any freedom to use the brands that you're planning to use. So why develop an IP strategy? Why not just jump in, get on with things, and then muddle through as and when? Well, I'm sure you're all aware every business is unique, and the needs of a private individual starting a small business from home is going to be very different from multinational. However, whatever business you're running, one of the main reasons for having an IP strategy is to manage risk. Whatever the size of the business, you will be investing time and money from a very early stage. And to get down the line with a product or a service or a brand that you've developed and find that you cannot use it because of some form of infringement, so some form of IP right that's out there, and someone approaching you saying, nope, you can't do that, is not good. So that's one of the main reasons, just to make sure that you're looking at that risk early on. It's also really helpful to make sure that any IP rights are available to you, that you're aware of what rights are available, and to secure ownership of them if you choose to do so. So part of the strategy might be deciding how much to spend, how much time to invest, what IP rights your business wants. So it's not essential to secure all the IP rights, but in general terms, IP rights will tend to increase the value of your business, and to be a really useful tool for you, say if you need to secure investment. So securing ownership of those IP rights can be really key. And if you don't have a strategy, there's a severe risk that you won't know what rights are available to you. There won't be anyone within your organization who's identifying what might be protectable in any way, and that some rights might be missed. So again, here we've got protecting chosen markets. We'll talk more about this later on, but most forms of IP have a cost associated with them. So having a strategy where you identify what markets are important to you and why, and then focusing on them is also really important. It doesn't have to be the same always. So you may well, certainly in a larger organization, have a significant amount of IP available to you and not always proceed in all the same markets with your protection. And the reason for doing all of this, as I've touched on, is really so that you can exploit value and monetize your IP. So it can add significant value to your company. It can be very helpful should you need to raise investment or wish to sell off any part of the business. And so having a clear strategy in place to identify IP, make sure that any protection is properly registered where registered rights are being used, or recorded where unregistered rights are being used, so that going forward that's available and clear to anybody. For example, if you have a due diligence process going on at any point with a sale, that can be really helpful. There's a lot on this slide. We're going to unpack it a bit more as we carry on, but that's the basics of why the strategy can be helpful to you. So this slide, again, there is a lot on here, but it's important to mention that an IP strategy will look very different for any business. And on the left of this slide, we've got all sorts of different factors that would feed into deciding on what your strategy might look like. So who are your competitors? Who may your competitors be in future? Looking at what they do with their IP, for example, can be very helpful in deciding on your own strategy. Finance, I've already mentioned that, for example, for securing investment, IP can be very helpful. It's sometimes a requirement for some forms of finance. So knowing what your financing model is can help again with working out what your strategy should be. Again, partnerships. So, for example, if you have suppliers or other businesses, especially if they are inputting to your R&D process, is there a clear strategy about who will own any IP that comes out of any R&D that you're doing jointly, for example? The way your organization functions will feed into your IP strategy. So I've talked about identifying what IP rights might be available to you. The way in the size of your business, is there one person who's going to be responsible for that? Do you need a system in place so that the various people who might be in a position to identify IP can communicate clearly? A lot of larger organizations have a department who are responsible for identifying potential patentable inventions, for example, and they will have systems in place to make sure that they are regularly communicating with anybody involved with R&D, anybody who may be aware of an invention, and they will have systems for feeding the information to them. They sometimes have a reward scheme to encourage people to do that as well. Then your market, that's obviously going to be key, particularly in terms of working out where you wish to secure IP, where you wish to exploit IP rights, and the sorts of products and services that you're providing will also largely determine what sorts of IP are available to your business and also are going to be most useful to your business. So all of those different factors will all be considered when developing your strategy. That's something we can help with. Obviously, it very much involves speaking with clients on an individual basis, understanding what they're doing, what's important to them. And then through all that, we can develop with you an IP strategy so to have a good, strong strategy, it's important to have both a policy and budget attached to it so that you're aware of what is realistic and achievable. And an IP strategy can help you achieve all these objectives that we have up here on the right-hand side. It's important to feed into your vision and your mission and your strategy. So as a business, your overall strategy. So the IP strategy really is key to enabling your business to get where it wants to be. So we've talked a little bit about markets. One of the key benefits of IP is to protect your market. Now, IP in general, so trademarks, designs, copyrights, patents, trade secrets, it's all territorial. So there are some systems out there which enable you to facilitate cross-border protection. So, for example, there's the unitary patent system, which covers a number of European countries, which we will talk about later. There are some international trademark systems, for example, but there isn't any IP right that is truly global. So when seeking advice, it is important to consider where is important for your business to secure protection and how to achieve that. So that the important thing to say there is a cost attached to most forms of IP, particularly the registered rights. So, for example, talking about patenting, to achieve a patent, there is normally a cost payable to each national patent office, and then there are renewal fees payable to each national patent office. So for almost any business, obtaining a patent globally is going to be exorbitantly expensive and not a sensible use of funds. So most businesses will develop an IP strategy looking at which key markets they wish to protect and know what the relevant costs are and conduct a cost benefit analysis and decide where to proceed. So it is, however, worth also being aware, as I've said here at the bottom, that if somebody else has rights in a country that you might want to expand into in future, so this is why it's worth thinking about not just the present situation of your business, but also any future plans or likely future plans. It's worth being aware of any of those rights because they could stop you going ahead. So that's something that we can help with as well. So moving on, I'm now going to spend a bit of time just delving slightly deeper into each of the main types of IP that we've talked about previously, just because having slightly more understanding of them will help you in developing your strategy. So starting with patent protection, I've mentioned previously, so patents are protecting technical inventions. An invention can have many different uses or embodiments. So they're not necessarily linked to a particular product. So one of the ways in which it's important to develop your strategy is that if you are a business developing a particular product, to be able to sit back and look at that product and take out the inventive concepts in there and then to see how they might be more broadly applied to other products is key. Sometimes that can enable you to achieve some really broad patent protection, which can be very helpful for stopping competitors doing similar or even different things. It can also enable you to license your invention to third parties and to gain some revenue that way. It's also worth saying that one product can include, I've said here, many different patentable inventions, thinking of something like an aircraft or a helicopter in aeronautics, for example, that would typically include hundreds of patented inventions in that one larger item. So again, seeking advice, looking at your whole product and what might be patentable and not assuming that you're limited to particular aspects of it is important. A really key thing with patent protection is that to be patentable, something must be new. And that is just one of the truths that is the same throughout the world and is really vital. So always file a patent application before making any public disclosure of your invention. That sounds straightforward. It can actually be quite hard to achieve. For example, if there's a research paper that someone's keen to get published before other parties, or marketing material going out and it might not fully disclose, but it has some hints. So it's worth having a really clear strategy to make sure that you get your inventions on file before disclosing them. So carrying on with patents, I've just said it's important to file before disclosing, which is true. There's a tension with this next point, which is that a patent application needs to describe an invention in enough detail to mean that somebody could make it. Now, it is someone who has relevant knowledge in the field, but it does mean that it's important to think about whether you have actually developed the invention in enough detail to mean that it is possible to file a patent application. So that, again, is something that's worth seeking advice on. I've mentioned this already, but making sure you're clear on your patent strategy. What are the costs going to be? Where do you want to file? Why? So yeah, where do you think your biggest markets will be? But also, is there somewhere else that you want to block a third party from operating, for example? The initial costs for filing patent applications are much lower than the subsequent costs when you want to go ahead and get protection in a number of different countries. So really having a clear strategy and knowing what it's going to cost you in the long run and what the benefits of that will be is key. It is worth mentioning that there are various funding streams available. So, for example, there are some grants both in the UK and the EU. There is also tax relief available, for example, under the UK Patent Box scheme. That is all very dependent on what your business is doing, the jurisdiction you're in. So it's something that's always worth seeking local advice on, but it can be very, very helpful. I do have clients who started out as private individuals and now have businesses with a number of patents where their first few patent applications were all funded under grants. So it is definitely worth considering. So to talk you through the patent process, we could spend an awful long time on this slide, so I will have to whistle through it to make sure it doesn't take too long. I've done this as if you're a UK business. Should you be operating from another country, then where you first file your patent application wouldn't necessarily be in the UK, but the process looks broadly the same. So when you're ready to file a patent application, you go ahead and you can file it just in one country, which is relatively inexpensive to do. So here we file in the UK at 0 months. The really good thing about that is you then get this initial 1 year, 12-month period before you have to go ahead and file patent applications in any other countries. And that's because the later applications can do something called claiming priority, which means they are deemed to have been filed on the same date as that original UK application. The year goes by very quickly, but it is really helpful in terms of making quite a small initial outlay, getting a patent application on file, and then being able to develop your invention, develop your product, talk to people, raise funding, see how your business is progressing before having to make a definite decision where you go ahead at the end of that 1 year. As I say, the year does go by quicker than people expect it to normally. Then at the 1 year stage, there are various options available. So at the top here, one possibility is just to file a number of separate national patent applications in each country that you want patent protection. And if you do that, they just carry on being prosecuted by national offices and hopefully eventually grant as a set of national patents. Another possibility is to file a European patent application. That's actually under the European Patent Convention and importantly is separate from the EU. European patent applications effectively hold a bundle of national European rights until grant. And the European Patent Convention covers a number of countries, including the UK and Turkey, as well as the EU countries that you might expect to see there. At the end of the prosecution process for a European patent application, so on grant, there are two options available. Either the European patent can be converted into separate national patents, which we've got here, or it is also possible to convert to a unitary patent. The unitary patent is a single granted patent that covers a number of European countries. However, importantly, the UK and other countries are not a member of the Unitary Patent Convention, but that can be dealt with by filing a unitary patent and a number of separate national patents to top up if required. And then finally, at the bottom here, this is an option that's often very popular with especially patent applicants who want protection in a large number of countries. We've got, you see this picture of the world, there's the International Patent Cooperation Treaty, which enables filing a single patent application which holds a bundle of rights for pretty much everywhere in the world. That can be filed at 12 months. The important thing to say is at 31 months from your original UK filing, that does then need to be split into further applications. It's possible to file a European patent application at that stage as well as nationals. So it only delays the costs, if you like, but it is very helpful for an individual or a business who think they're going to want patent protection in a large number of countries to file this international patent application, PCT, we call it, at 12 months, and then they have a delay before they have to really think about where they're going to invest in the national applications, because at that stage there is significant expense. So sorry, that's a bit of a whistle-stop tour, but I don't want to take up too long on these processes. So moving on to design protection, which I'm not going to talk about in as much depth, but it's really important to say design protection, as you'd probably guess, is about the aesthetics of a product. It's not about the technical function. So typically it covers the shape and configuration of a product. And there are two main sorts of design protection. There is registered design protection, which again tends to be a national right, where you actually apply for registered designs in any countries in which you want to have protection. There is also unregistered design right, which is again available in most countries. And that functions, well, depending on the law of the country, but it's not a registered right. So it's something that arises automatically. It can be harder to prove its existence, but it can also be useful. Again, I would recommend seeking advice. Often both registered and unregistered design right can be useful, and certainly a number of people would use both in tandem. Turning to copyright. So again, people will probably be very aware of copyright, for example, from the music industry and the film industry. Copyright is actually very, very broad. It's a right that protects creations. So I've got here that it includes written work, artistic work, music, software, databases, web layouts, but it will also cover other things. Copyright protection is automatic. Certainly in the UK, there's no copyright register. It is purely automatic. It's not entirely the same process in every country. So it is something that it's important to seek local advice on if copyright looks like it would be important for you and if you want to rely on it. In the UK, at least, the duration of copyright is often the life of the author plus 70 years, which is much, much longer than a lot of other rights. For example, a registered patent only lasts for 20 years from the date of filing. So although there are some things about copyright that can be difficult, for example, proving that it exists and you own it and that someone has copied your copyright, it has the advantage of having this long duration. I've also wanted to mention domain names very briefly. Domain names aren't actually IP, but they're so closely related to your branding and your any business activities that it's worth just briefly mentioning them. So you'll be aware that a domain name is really just a sequence of characters which identifies a section of the internet. One of the reasons a domain name is important is that you do need to register your domain name and renew it every year. We do see clients who haven't registered a domain name or haven't done trademark searching, and then they start using a business name linked to their domain name and find that they have a problem. So it is really worth including domain names in your strategy and thinking about that. Turning to trademark protection, which I suspect people will be slightly more familiar with. As you're probably aware, a trademark is a sign that distinguishes the goods or services of one trader from those of another. And importantly, a trademark gives the owner the exclusive right to use the mark in relation to specified goods or services. So it's not necessarily all goods or services, it is goods or services in certain sectors as specified. Trademarks cover a huge array of options, but they can include business names, they can include product names, they can include slogans, importantly also visuals, so logos, 3D shapes, color combinations and patterns, and lots more. So again, I think we often think of trademarks just being things like the brand names that we're very familiar with. It is really worth looking at trademarks properly in your business strategy and seeking advice to make sure that you've identified all those trademarks within your business activities that should be protected. So trademarks, again, there are registered trademark rights and there are also unregistered trademark rights. As with designs, it's often useful to use both in tandem. The registered rights are often easier to enforce. Significantly, as long as trademark rights are renewed, there can be indefinite protection from them. So again, very different from patents where the maximum term available is 20 years. And this last point, this beware, this is really very similar to what I said about the domain names. So yes, you can do business under a name on an unregistered basis. But if there is a registered trademark out there that you're infringing, that can then stop you trading under that name, which obviously is not helpful for a business. So it is worth making sure that you have the relevant freedom to operate before you start trading. Turning to freedom to operate more broadly. So I've said this in terms of patents, but it's actually true of many other registered rights in a similar way. So a patent grants the right to stop others from working your invention. However, it doesn't mean that you're entitled to work your invention. So because of that, it's quite possible that there might be other IP rights out there, for example, patents, that you would infringe by carrying out the activities that you are doing, even if you have a granted patent for them. So it's very important to do the relevant freedom to operate searches, see what's out there, and make sure that you're not infringing any third-party rights. I've said here, early searching and advice is key. That's true of so much of this. Really, the earlier you're able to look at what might be out there and what might cause you a problem, the easier it is to decide how best to proceed. And we'll talk about that a bit more on one of the next slides. Yeah, over here I've said carry out any searching before launching operations or products, which is really what we've just said. Importantly, in patents, saying that you were ignorant of the existence of another patent is not a defense to infringement. So choosing to bury your head in the sand, not doing the searching, can be very dangerous, because somebody with a granted patent can stop your business from carrying on the relevant processes, and it can involve having to withdraw a product from market or stop using a particular manufacturing process, and can obviously be very damaging to your business. So looking at freedom to operate in a bit more detail, I've said it's all about risk management. However much searching you have carried out, however much advice you take, there is no guarantee that everything will have been found. However, the more you do look, the more you do carry out freedom to operate searches, the more likely you are to know what is out there and to be able to proceed safely. If something does come up, so if an IP right does come up from a third party that is going to cause you a problem, how worried should you be? So first of all, always seek advice, don't panic. Not always, quite often someone might say that their IP right, they might write you a cease and desist letter, for example, and say, we have this right, you need to stop. Does what they have actually cover your activities? If it does, can you design around it? Can you get around it somehow? And even if the answer to both of those is that yes, it does cover your activities, and no, you can't design around it, would the third party actually sue you? Would they win? Are there other reasons that their IP right is invalid, for example? So it is really worth taking advice and looking at this in detail if an issue does arise. You can also think of taking a license from the IP right owner if they're amenable to that, or challenging the validity of their IP. If you haven't been approached by a third party, if you've just found something without, through a search, and they're not aware that you're aware of it, there is of course a possibility of choosing to do nothing and hoping that the problem never comes to light. So these are all things to take advice on and to think about when you actually have a particular situation that's relevant to your business. Looking at trade secrets now, which is something people typically aren't so aware of, but can be really key. So I've said here, trade secrets are an integral part of any IP portfolio. And I've given you the definition of a trade secret because it's less clear than a lot of other IP rights. So the definition isn't the same everywhere, but in the EU, the UK, and the USA, a trade secret covers confidential information that's delimited. So it's really important to have clear documentation setting out what is known, what is not known in the relevant circles of trade. So clear documentation setting out what your trade secret is. The trade secret has to have value from being kept secret, and measures have to be taken to keep it secret. So the Coca-Cola formula is probably the most well-known example. So it's important to note that the definition of a trade secret is often formed over time and is flexible. So with something like a patent application or most of the registered rights, you file an application for that right and that's it, it's there. And whatever you've defined in that application is what the right is. Whereas with trade secrets, they can vary. As the technology develops over time, it is possible for that trade secret to change with the developments. And it's also important to say that confidentiality must be managed. So an example of where that can be really difficult is in universities and research institutions where there is
maybe we can just move to the
there is a real tension between wanting to publish and discuss what you're doing, maybe to raise funding or for other reasons, but actually it is important to maintain that confidentiality or the trade secret will cease to exist. This slide has a lot of information on it, so I probably won't go through all of this in detail. I might leave people just to look at this, but not everything is a trade secret. So it's probably worth mentioning if information is old or obsolete, no longer commercially valuable, that's not going to be a trade secret. Information that's remote from business activities. Again, here R&D results which have been published, that's what we talked about. And also general knowledge and experience that an employee has. So not everything is a trade secret. So again, seeking advice on it is what we have here actually a trade secret that we can protect as such. So in Dehns, we do work with trade secrets with our clients. We give you the opportunity of considering these as an integral part of your IP portfolio. We can record them for you. So here on the right-hand side at the bottom, we've got an example template that we would use. So we can help you to look at your business, identify any trade secrets that you might have and to record them. And then we can also work with you to, as I say here, reconfirm any recorded trade secrets. So that's really checking in at regular intervals to see that they are still trade secrets, to see whether they've developed and to make sure that they are still accurately recorded. Also, as I just mentioned, looking at how your trade secrets align with patents and design applications. Those are the main types of IP that they would align with, but making sure that all your different forms of IP protection are working together and being used effectively. And it's also important to say that using trade secrets, thinking about how they link in with openness and or secrecy is really vital. Do you want to keep this secret, or actually would it be more valuable to your business to publish it in some way? So how can we help? Obviously, talked through a lot here. I apologise, there's so much information, probably information overload for some people, but these are the main ways in which we can help with IP for your business and with IP strategy. So firstly, at the top I've put help with identifying, filing and securing patents, trademarks, designs. We can help with analytics and investigations. So we can carry out searches to look at freedom to operate, also to monitor IP from named competitors. So if you have particular competitors who you want to watch, and to help advise on the right combination of patents and other IP protection for your business. Due diligence, this often comes up if a business is being sold or part of a business is being sold, so we can confirm IP rights and report on their strengths, produce relevant reports for whoever needs to see them. So we can work with you for investment and capital raising, both with investors and with companies. And there we would assess ownership of IP, the risk associated with IP and the value of it. We can assist with creating IP strategies, which is very much what we've been talking about. We can assist with licensing and collaboration. So we haven't really talked about licensing, but many IP rights it is possible to license or to have collaboration agreements, which can be very helpful for your business in moving forward, say in developing a product. We can review a portfolio, so we can offer to come in and look at all your IP and advise on whether there are gaps or other actions you could take to improve the strength of your IP portfolio. And we can also help with valuing IP, which can be really key for any sort of transaction, for example, sale of a business, also for collaborations or sometimes for internal matters for a business to work out how best to prioritize and how best to proceed. So I have come to the end of the presentation. I can see there've been a number of hands raised, but I've actually carried on talking. I think, Zena, there's probably a bit of time for questions now. Is that right?
Yeah, we're thank you so much first, Philippa. It is such a complicated area, and I think that you helped simplify it to a degree for us. But I think getting expert help in this field and knowing when to get expert help is going to be absolutely key.
Yeah,
so thank
absolutely.
you. So we have had a question, and as I say, we can fit in one or two questions. I appreciate we're a little over time, so some people may have left us, but it's Adita, and I think I understand the question, but if you'd like to come off mute and give a bit more context, you can. But it was when you were talking about the patent slide, and the piece around that if you have a patent, it doesn't give you the right to work at it, which was something you mentioned. I wondered if you could clarify that a little bit.
Yeah, so with patents, when you file a patent application, basically what you do is you identify what your new inventive concept is. And as long as no one has done that before, so as long as that is new and what we call inventive, you can get a granted patent. But it's quite possible that someone else might have a granted patent which covers your activities. So it's probably easiest to think of it almost in terms of a Venn diagram. So someone might have a granted patent for something which encompasses what you're doing. And so although you've got your granted patent for your invention, you would still infringe their patent rights. So because of that, it's really important to look separately. So that's where we were talking about the freedom to operate. So it's best really to look at it as almost two totally separate factors. There's protecting what you're doing so that you can stop people from doing what you're doing. But sometimes someone else might have something, an IP right, which means that they can stop you. I'm trying to think of a good example. It's typically, it might just be something like they came up with a patent for a really broad concept. And then what you're doing is a more detailed development of it. So what your activities fall within what they're doing, even though you can get a granted patent for them. That's probably the simplest way of saying it. Does that help?
Thank you for that. We will find out. If you want to add any more comments or to that question, then please do. Does anyone else have a final question for Philippa? No? Okay. Well, thank you so much again, Philippa. And yeah, that brings us to the end of today's session. Keep your eyes posted on email for October's session, yet to be confirmed. So do keep a look at, and we hope you will join us at the next session and at the Ideas UK conference too. So thank you for today and enjoy the rest of your day.
Thank you.
Thanks, everyone. Bye now.